as well as the effect of security laws on human rights and the role of law in the subordination of women, as well as the crimes of enforced disappearances and torture in conflict areas. Time magazine even identified her as one of the 100 most influential people in the world in 2013. She received an honorary degree from the School of Oriental and African Studies, University of London, for her in recognition of her contribution to the area of human rights and civil liberties, and that happened in 2018. Another lawyer practicing at the Supreme Court of India is Rashmi Singh. She's also based in New Delhi. She's practicing primarily in the Supreme Court of India in the last 8 years. She has been actively involved in various pro bono matters, such as representing the protesters of the Shaheen Bagh before the Supreme Court, as well as filing writ petitions challenging the CAA, that's the Citizenship Amendment Act, on behalf of the Shaheen Bagh protesters. She has also filed an intervention application on behalf of Muslim women in the petition demanding universal civil code with respect to marital laws. She has assisted Ms. Meenakshi Arora, who is a senior advocate in the Babri Masjid demolition matter before the Supreme Court for the Sunni Waqf Board. She's filed petitions on behalf of slum dwellers from Gurgaon who were facing untimely demolition of their slums following that was before the High Court of Punjab and Haryana, as well as the Supreme Court. The next panelist is Dr. Waris Hussain. He is an adjunct professor of international law at the Howard University School of Law in Washington, D.C. Dr. Hussain is a human rights attorney working in Washington and has assisted several individuals facing sedition and UAPA charges in India. Dr. Hussain is a former policy analyst for the U.S. Commission on International Religious Freedom covering India. He holds a JD, an LLM, and doctoral legal degrees in comparative constitutional law. Suchitra Vijayan was born and raised in Madras, India. She is the author of Midnight Borders, A People's History of Modern India. I just want to say that this is a great book, highly recommend it. Her work has appeared in the Washington Post, GQ, the Boston Review, The Nation, and Foreign Policy. A barrister by training, she previously worked for the United Nations War Crimes Tribunals in Yugoslavia and Rwanda before co-founding the Resettlement Legal Aid Project in Cairo, which gives legal aid to Iraqi refugees. She is an award-winning photographer, the founder and executive director of the Polish Project, which is a hybrid research and journalism organization. So it's a very esteemed panel that we have here today. I'm very honored to be even speaking in this panel. And I just wanted to say very quickly before we go to Brenda Grover, is that the term prisoner of conscience was coined in the early 1960s. Actually, was coined by Amnesty International to raise the voice of the voiceless who are imprisoned for their beliefs. And today in India, we see freedom of expression curtailed because of laws that permit detention, for preventative detention, ostensibly on quote charges of terrorism, that end up stifling freedom of expression. And so you have a situation where you have people who are imprisoned solely for their political beliefs, but it also contributes to a climate of silencing those who fear being put into prison. And so that is just a grave concern that we've seen growing in ever more over the years in India. And so I want to turn it over now to Brenda Grover, the senior advocate on the Supreme Court of India, to talk more about this. So thank you.
Thanks, Govind, and thank you for this invitation to speak here. on this topic, which I think is of great urgency. I would also request you, Govind, if you could just, when I have a minute left, signal to me. Lawyers don't stop talking unless they are asked to keep quiet.
I will do so.
So while I will speak on what is popularly described as the Bhima Koregaon case, I think what I'm trying to also indicate through that illustration is that how is the legal infrastructure and the legal regime today being deployed and weaponized in order to actually suppress, crush, not just dissent, but any form of freedom of speech and expression, any form of freedom of association, and any form of opposition to the dominant politics, which is a dangerous combination of not just Hindutva supremacist, but also in conjunction with corporates, both Indian and multinational. And that is the context in which we need to understand what in India we have started, we were calling as BK16, because there were 16 persons who are incarcerated, and today they are BK15, with the Jesuit priest and activist Father Stan Swami having lost his life while in judicial custody in the month of July. And very often nowadays in India, we use the phrase that the process is the punishment. I think with the judicial, institutional death of Father Stan Swami, we need to now understand that these people have been condemned to punishment. This is a sentence that he has suffered without any due process or trial. And that is where BK15 is now located. Very quickly to say, who are these people? In a country where the Modi regime now since 2014 onwards has had a brute majority in parliament and is perhaps one of the richest political parties in the world. The opposition today is being provided by civil society activists. And therefore, the targeting of civil society by the government has to be understood in that context. Who are these people? I'll take just a few examples. As I mentioned, Father Stan Swami, who had dedicated his life to seeing what could be done for the betterment of the lives of Adivasis or the indigenous populations, who are on all indicators amongst the most oppressed sections in Indian society. Sudha Bharadwaj, again, organizing workers, organizing indigenous populations for securing their socio-economic political rights. Mahesh Raut, a young activist, organizing people in rural India to be able to protect their land and access to natural resources. Each one of them are people who not only disagree and dissent from the form of governance, including the economic model of governance that India has adopted, but who are actively engaged in organizing people peacefully to secure their rights. And that is the context in which they need to be, this case needs to be understood. The arrest began in June of 2018. It's a case that has not yet been closed by the investigating agency, which has passed from the hands of the anti-terror squad of Maharashtra to the National Investigating Agency. It is not the case of the state that any of these people were linked to any violence at Bhima Koregaon on January 1st, 2018 in Maharashtra, nor is it anybody's case that any of them have actively participated in violence. What links, what is it which has brought upon them this draconian Unlawful Activities Prevention Act? The evidence, the state claims, are a bunch of documents found in devices, because when the searches and seizures took place and raids took place in the homes of the activists, what was picked up were devices, electronic devices, phones, computers, laptops, hard disks. And it was claimed in a sensational claim before putting in court. It's of course thrown in the media in India very frequently, that letters have been found on devices of one of them. I'll leave aside for the moment whether these letters will ever be admissible under law. They are not dated, they are not signed. They are typed documents. Whether they will pass this test of scrutiny of evidence law in a court of law will remain to be seen. These documents, it was claimed, link all of them found in the device of one to various Maoist activities and organizations. In the last year, the defendants have actually got two of them have got their devices analyzed, which has now told us through Arsenal Digital Forensic investigation that these documents, which is the fulcrum of the case of the state, and for which reason they have been incarcerated since 2018, these were planted through a malware called Netwire. So the authenticity, the genuineness of these documents, which the accused have consistently from inception denied complete knowledge of, is today under a huge cloud. And we have the state not responding to it, not even saying we are open to, if the state is sure of its case, they should say, let's have an open investigation. Let's have an independent forensic investigation. The state is opposing it tooth and nail. So what is the purpose of this incarceration? And a law which actually makes bail near impossible, because the court has to see whether prima facie there is no case against the accused. It is a little laughable. Anybody with even rudimentary knowledge of law would know that when the police is going to file its documents, its charge sheet as it's called in India, it will make out some case. And if in those documents you're going to make outlandish claims that these people are linked to Maoist activity, they're going to assassinate the prime minister, it will sound like a very large, serious, dangerous conspiracy to overwhelm the mind of the court. And the court is supposed to see whether prima facie there is a case made out of terrorism. Again,
One more minute.
A phrase that has defied any legal definition internationally. And because of that, they remain incarcerated since 2018 with no trial in progress. Charge sheets after charge sheets being filed, people being arrested, activists and human rights defenders being arrested on the basis of evidence that will never withstand judicial scrutiny. And yet they have been able to therefore silence people who would have been able to organize democratically, people whose rights are being taken away, while corporates are marauding areas where indigenous populations are surviving, as well as have a chilling effect on anyone who wishes to engage in democratic public activities of association and protest. So this is the way law has been used. And I think it is time for human rights defenders, human rights lawyers to revisit what is the purpose that law is today playing and the legal system is today playing, and what is the challenge that it throws to democracy itself. I'll stop there.
Thank you. That was very helpful. Okay, let's go to we'll have time also for questions if you'd like to when there's follow up at the end. Now let's turn it over now to Waris Hussain.
Thanks, Govind. Thanks everyone and the organizers for this briefing, which I'm very happy having worked on Congress at a commission. These kinds of briefings were very essential for us forming our policies from the US government perspective. So having these as a consistent sort of input is great. And I'm really thankful to the organizers for taking this up. I mean, as is always the case, Ms. Grover presents us with a very vivid picture of what the on-the-ground reality for human rights defenders is today in India, right? Undoubtedly, the case of the Bhima Koregaon accused will go down in Indian history as one of the most serious and abrasive attacks on the human rights defender community in the country. And unfortunately, as her comments demonstrate, this won't be the last one. It seems like there will be more coming up, and the same pattern will likely be used. But what I wanted to do, since we have such eminent sort of practitioners who actually have practiced the Supreme Court whereas I'm coming at it from more of an academic lens as a human rights advocate myself, but also as a professor of law. My comments are going to focus less on a particular case relating to the prisoners of conscience, and I'm going to focus more on the infrastructure of oppression that leads a human rights defender to become a prisoner of conscience, right? It doesn't happen in a vacuum. And one might think that the issues relating to prisoners of conscience merely deal with the criminal justice system, but that actually is not the full picture. There are many parts to this infrastructure, but let's focus on three for today. Let's focus on the social apparatus, the digital apparatus, and then finally the legal apparatus, which is what Ms. Grover was talking about as well. Starting with the social apparatus used to punish human rights defenders fighting for a fair and just future for the country. Whenever someone speaks against the current ruling administration, they are likely to face social pressure to quiet them and attack their dignity in a very public format. When it comes to human rights defenders working in the Muslim community, they will be called terrorists. When it comes to defenders working to assist workers or students, they will be called drug dealers or drug takers. And when it comes to people working on gender issues, they will be called prostitutes or members of the sex industry, or other terms that are meant to demean and destroy the dignity of those human rights defenders, right? And I think that's the social pressure that's put on. And how does this happen? It can happen through the police and politicians making press conferences and public statements to malign the character and credibility of human rights activists, most often with false allegations. And as is often the case with false allegations, as long as they're sensational enough, some media groups will run the story and spread it throughout the country. This means, as a human rights defender, one has to be willing to allow their family's reputation to be dragged through the mud, which can in some cases lead to an estrangement from the family, right? And this means that when a human rights defender goes into prison, they are not going to have the same social support as they might have otherwise had without the social apparatus working, right? And if you think that prison is bad or it's very tough to deal with, imagine prison without having any family support, without having any of that background community sort of support that you need to get through that very tough period in your life. That's unbearable, right? And that's part of this process. And as Ms. Grover said, the punishment is the process itself, right? And if that's the case, then in addition to just being put in jail and being taken away from your family, there's also an attempt to try and malign the character of that person and their family to maybe create more estrangement between them. Oftentimes we see very brave families supporting the human rights activists that are part of their families and standing by them. But oftentimes there's a lot of pressure put on those families to cut off ties from that person. And that leaves them even more lonely, even more depressed, even more subject to this kind of mental punishment that's happening through their imprisonment. So let's move on. As I said, we're going to go through three. Let's move on to the digital apparatus that helps create the prisoners of conscience. Without a doubt, the revelations about the NSO hacking of human rights defenders around the world should be a wake-up call to anyone advocating for freedom or democracy in the world. In some instances, the unauthorized and illegal monitoring of phone is used to collect sensitive private information that can then be used to blackmail or publicly malign the character of human rights defenders, as I mentioned before with the social pressure. However, the problem in India is that the buck doesn't stop there. As has been found in the Bhima Koregan case, malicious actors are not only surveilling the defender's digital devices, but they're implanting false information on those devices. Once that malicious and inauthentic material is placed on the phone or computer of the human rights defender, the police and prosecution then rely on that fake material to prosecute individuals for crimes as serious as terrorism or sedition. Now we can finally get to, and this is a very, by the way, I violated the principles of being a lawyer and just talking about the law, because I want to talk about the social, I want to talk about the digital, because we need to be holistic in the way we're looking at this confrontation with the state. Finally, let's get back to the law, so I can at least earn my keep as an adjunct professor, right? The prisoner of conscience infrastructure is really based on the law and the criminal prosecution. And first, one has to remember that for prisoners of conscience, the process is a punishment, exactly what Ms. Grover said. So by using British colonial era laws concerning terrorism or sedition, the state can hold a prisoner of conscience for months, and in fact, even years before starting in earnest with the trial. That is not what the process is supposed to do. The process is supposed to be speedy. It's supposed to provide justice to both the victims and to the individual who's accused of the crime. It's not supposed to be used as a battering ram, right, to try and stop those individuals from engaging in the work that they're doing. But this is what we're seeing. We're seeing these older era laws being now used and modernized. And so again, this violates international law. It violates norms in Indian constitutional law relating to due process and speedy trial. And laws that are meant to combat terrorism in the country are now being weaponized against human rights defenders with the sole aim of silencing them through intimidation. And the prisoner is not the only target. And Govind, I would really emphasize this. In a prisoner of conscience case, we oftentimes focus on the prisoner. Here, it's not just the prisoner that's the target. The government is creating a chilling factor for anyone, any young person, any student, that they don't engage in this human rights advocacy, that they don't test the government on what they're saying, that they don't criticize them in a public matter, lest they be subject to the same Orwellian injustice system, right? And I wouldn't call it a justice system. Now it's become controverted into an injustice system, and a very systematic thing at that, as I've explained, with the digital apparatus, the social apparatus, and the legal apparatus. So this isn't just some random happenstance things the government is doing, right? This is a very systematic view on how to structurally diminish and demolish, really diminish and demolish the ability of the human rights community to hold the government to account. So one has to understand that there's this entire infrastructure in place to silence these advocates in the country and turn them into prisoners of conscience. There are those social, digital, and legal systems working together to punish.
One more minute.
I'm not even going to take the minute. That's how I'm going to end it, Grover. Govind. There are social, digital, and legal systems in place for people that do speak out. And for people that could speak out, all of this is an intimidation factor, right? So we're not just addressing, because oftentimes when we think about prisoners of conscience, we think about those people who are in jail. And that's absolutely some of the people that we're absolutely concerned about. What I'm also concerned about, what I believe all of the people, the speakers in this room are also concerned about, is what about the 19-year-old young student who wants to go out in the street and protest? But now they have to deal with seeing these kinds of news stories, maligning people who are senior advocates in the field. They have to see the digital tools being used to repress those individuals. And then finally, they have to see those people put in handcuffs and taken by national security officers into prisons accused of terrorism or sedition. This is what they're seeing. So really, the calculation for them is going to be much more different. And then the future of human rights in India and the future of the advocacy of human rights in India is going to be at stake. So it's not always just about the prisoner of conscience. It's about the rest of the country being put in a prison as well. So that's where I'll end my note, Govind, and I'll pass it back to you.
Yeah, thank you very much. Thank you for those thoughts. Now let's go to Suchitra. Why am I having trouble? Of course, Suchitra Vijayan. Go ahead.
Thank you, Govind. I want to start by thanking everybody in the panel today for the work that they do in defending the rights of citizens in India, but also defending those who are the farthest away from power. But also a moment to thank the many, many social activists and others on the ground, young students who have all been organizing in many, many ways. I think it's important for us to consistently keep speaking and also making sure that the rights that are being increasingly eroded are being challenged, that we continue to speak and also challenge. I'm actually going to start my statement with a quote with lawyer Brenda Grover, who spoke earlier today in the panel. I'm quoting her. UAPA has become a convenient tool to target activists, religious and ethnic minorities, and to spawn fear among people to manufacture a rationale for an authoritarian state to act with impunity. And I think what is really important in my statement, one thing that I do want all of you to take away from my statement is to understand that this is an authoritarian state that acts with impunity. India continues to be referred to as the world's largest democracy. However, it is now a state that uses both authoritarian means and ends to silence dissent. This year, the US-based nonprofit Freedom House downgraded India from a free democracy to a partially free democracy. The Sweden-based Freedom Institute said that India has become an electoral autocracy, and Democracy Index, published by the Economist Intelligence Unit, described India as a flawed democracy. It's imperative that we understand what's happening in India, not just as an aberration, but carefully calibrated acts of authoritarian regime. So also it's important for us to see India as a national security carceral state that is waging a war against its own people. Authoritarian regimes effectively use and mobilize existing laws, institutions, and importantly, the police and the judiciary to criminalize dissent and target those who continue to challenge the current regime and its various affiliates. And I think you've already heard some wonderful examples of this with both our previous speakers. Of course, we all understand that the UAPA is a lawless law. With only 2% convictions, these India's terror laws and sedition laws are a political weapon to silence activists, target students, demonize Muslims, Kashmiris, and any resisting population as terrorists. For example, recently, 127 Indian Muslims charged with terror were acquitted after 19 years. The law, as rightly pointed before, used disproportionately to target Dalit and Bahujan activists and those in Adivasi communities, many who continue to fight the illegal and unconstitutional encroachment of their lands. The extraordinarily wide definition of the term terrorist under the UAPA is being used by police across the country as an invitation to categorize all acts, even the act of turning up to protest, as a terror offense. Barring some exceptions, judges have routinely upheld the legal validity of these draconian laws to a point where now we are celebrating the judges for just simply turning up and sometimes just doing their job. In recent years, of course, scores of journalists, activists, students have been booked under the UAPA, leading to widespread criticism. But that's all there is. We have criticism, but the law has remained. Also, according to the recent data shared by the Indian Home Ministry in the Parliament, again, we know that India doesn't keep data well. So even whatever data that we have, I'm assuming that this is a very small number, is that there was a 72% increase in the number of arrests made under UAPA in 2019 compared to the number made in 2015. The government data also shows that 5,922 people were arrested under the law between 2016 and 19, and only 132 were convicted, which again goes back to our less than 2% conviction rates. The goal, of course, is to be unkind and cruel, unjust, and above all means use all the means necessary, whether it's legal, procedural, political, to not only destroy dissent, but also weaponize the very constitution against the people it's meant to protect. Once the democratic Indian state has now been undermined, eroded, and now close to being dismantled. And I think that's very important. The idea that the systems are being dismantled every single day. When the state treats its citizens as an existential threat, that state ceases to be a democracy. And I think it's very important for us to name the beast if we are to fight the beast. Before I conclude, I'm going to use two case studies and examples. Of course, lawyer Brenda Grover has already talked about the BK16 and now BK15 political prisoners. I'm going to very briefly speak about Jahan, who was an ex-Congress councillor and she was a local politician. She was, of course, like many others, actively involved in the protests against the new citizenship law in the fall of 2019. And while the protests were happening, the streets of India saw unexpected amount of people coming in. Shine Bagh became a center of hope. Soon after, you saw people like Kapil Mishra use hate speech and weaponize hate speech as a way to incite violence. And soon the Delhi pogrom happened, and then she was arrested on 26th of February while the pogrom raged in Northeast Delhi that claimed over 53 lives, 2/3 of whom were Muslims. Initially, she was charged with attempted murder, a charge that the judge found debatable and granted her bail. However, on the 21st of March, she was arrested again for conspiring in the Northeast Delhi case, the violence case again. All the accused in this FIR have been charged in the UAPA, and it's also, again, impossible to get bail on all of this. Ishrat has completed over 500 days in jail, and her family and her lawyers have been relentlessly trying to build cases and gather evidence. And what's really interesting in Ishrat's case is that one of the biggest problems that the lawyers and the family are facing is gathering evidence, because the Delhi police has been going around destroying several CCTV cameras in the areas that could actually acquit Ishrat. And there are also videos of the police going around destroying the CCTV. Of course, there's also Umar Khalid. It's also Umar Khalid's birthday today. Umar Khalid turns 34 inside prison. He's a human rights activist, a former research scholar at Jawaharlal Nehru University, and a vocal critique of the Indian government's anti-minority policies. He was arrested on the 13th of September, 2020. Again, Khalid believed that the CAA and NRC were not only unconstitutional laws, but it was an attempt to institutionalize the Hindu Rashtra and erode the constitution. He attended numerous protests between December 2019 and February 2020, and he delivered a speech. He delivered various speeches at various protest sites. And on the 17th of February, he delivered a speech in Amaravati, and then BJP leaders and right-wing media houses shared his speech, edited out without context, where he's asking people to come and protest, which was again interpreted as being him asking people to come and cause violence. Following such claims, he was arrested. He's been, again, there's no real evidence. There have been various charges filed against him. Again, under UAPA, there's a claim that he was planning a big blast. Again, if you read the charge sheet, it sounds, I don't know what to call it. It's not dystopian, it's not Kafkaesque, it's something else altogether. I think we've also lost the real language to really explain what's going on the ground. And
one more minute.
And then what we've also seen in all of this is that young boys from these communities were also later picked up and forced by the Delhi police to actually give evidence against Omar. I'm going to finish with a statement that Omar made just before he was arrested. As he says, do not be afraid, speak up against injustice, ask for the release of those who are being implicated in false cases, and raise your voice against every kind of tyranny. Thank you so much.
Thank you very much. And now, last but not least, we'll go to Rashmi Singh.
Hi, good evening. Thank you for this opportunity. A lot has already been said about prisoners of conscience, but to me, they're just people who have a very high empathy quotient and, who choose to not look the other way in the face of injustice. And I guess all of us are also prisoners of our own conscience, which is why we're here. UAPA has already been highlighted by the other panelists. So I will talk about another draconian law, according to me, which is being invoked time and again. That is the national. So this act was, it came into existence in the 31st year of our republic. And there is an unfettered amount of power that is given to the authorities under this act. And in the recent times, it has been it's been on the news a lot, especially if you talk about Uttar Pradesh, of which the example of which I will take. But before I get into the example, just what kind of wide powers the executive authorities enjoy under this act will be put into perspective once we compare them with the general principles of criminal jurisprudence. So a person who is arrested under criminal law will get the rights of being produced before a magistrate within 24 hours, the right to a legal counsel, and the right to, being informed about charges, etc. But under NSA, these rights are not available. In fact, under NSA, a person can be detained for 10 days without even being told about the reason for his arrest. He's allowed to only make a representation as to why this extrajudicial detention is inappropriate, and no legal counsel is made available at the stage of this representation. Up to 3 months, a person can be detained, and for an order of detention extending beyond 3 months, a panel has to be consulted, which is an advisory panel consisting of 3 members. If this panel approves of the detention, then a person can be detained up to 12 months extrajudicially, that is, without a trial. So with this in mind, now we will just proceed on to the case that I want to talk about and how NSA has been abused in it. And it's a very famous case. It's the case of Dr. Kaffir Khan. I'm sure everybody has heard about him. Just a brief background is that he's a doctor. He used to work in the Department of Pediatrics at the BRT Medical College in Gorakhpur, Uttar Pradesh. And his friction with the state government started when he criticized the cuts in public spending, and which was followed by an oxygen tragedy that happened in that particular hospital. So there was a oxygen supply crisis that led to the death of many infants, unfortunately, because the doctors were left helpless. He was arrested under various statutes, like the Indian Penal Code, the Prevention of Corruption Act, and the Indian Medical Council Act. And he spent 9 months in jail. But anyway, in September of 2020, he was finally absolved. Sorry, 2019, he was absolved of all charges. Then, however, his luck wasn't to continue for too long, as one can say. He was arrested in a very dramatic manner at the Bombay airport in January 2020 for having made a speech at an anti-CA protest in Aligarh the month before, that is in December 2019. Now, a few dates that follow in this matter will basically highlight how this particular statute is abused. So on the 10th of February 2020, he was given bail by the magistrate. But he was neither released nor was he produced before the magistrate, even though the bail order, and if somebody goes into the judgment and actually reads this in detail, even to the time, I mean, the order was delivered at 5:30. Authorities say that we only got it at 8:30. I mean, such discrepancies were there. Anyway, because he wasn't released on the 10th of February, on the 13th of February, the Chief Judicial Magistrate again passed an order that directing the authorities to ensure that he's released. On the 13th of February itself, the authorities went ahead and invoked NSA against him, and he wasn't released. The detention was extended by another 3 months. Then it was again extended on the 17th of August 2020. So he spent a total of 217 days in jail for something for which I don't know, the trial is still pending, the case is still pending, so I don't want to comment on the final outcome. But the High Court didn't really find anything, right? But I'll just get into that. So his habeas corpus petition went to the Supreme Court. The Supreme Court transmitted it to the High Court, and the High Court finally did come to his rescue and passed a very laudable judgment, the Allahabad High Court, in which the Allahabad High Court, it's a judgment worth reading. It's a 1st September 2020 judgment, and I'm quoting a line from it, where the Allahabad High Court said that preventive detention is an exceptional mode to curtail liberty and freedom of a person in exceptionally rare circumstances. In fact, the High Court went on to say that the police had failed to show any objective material that led to their subjective satisfaction under the NSA. In fact, they reached the so-called subjective satisfaction in the most whimsical and humorous manner. This is what the High Court said about the police. So despite all of this, we have a few cases, once in a blue moon, where the courts do come to the rescue of innocent people who are behind the bars. Still, we have lakhs of prisoners who are languishing behind jails. And just to add to what the other panelists have already said, we feel like we live in times of an undeclared emergency, which is far more dangerous than living in the time. Not that I haven't really seen the times when there was in fact an emergency in place, but because this is undeclared, one cannot really ask for its termination. So, rampant abuse to the point that, when people were pasting posters questioning the vaccine policy of the government, just for pasting those posters, those people were arrested. People are arrested for making a speech where they question the laws and policies of the government. And once you're arrested, the process is never ending then. So, that's my limited point, is just this much, that Dr. Khan's case is one where we see a happy ending at, where the court came to his rescue. But otherwise, it's a pretty dark place where we're at right now. Thank you.
Thank you very much. So appreciate all of these comments. I've actually learned quite a bit myself. We do have a few questions. I'm going to sort of take them one at a time. But the first one was, I want to just talk a little bit. I'm going to rephrase a bit of what was asked. But there's a question about how, if anyone has any comments about whether or not it has, in fact, and it's almost to Rashmi's point at the end there, if it's gotten worse under this government, or whether or not there have been some improvements, but the past was also not as good. I just want to see if anyone has any comments about that. I guess it's kind of challenging the notion that, it's worse now than it was, quote unquote. And so wondering if anyone wants to tackle that. Otherwise, I might just volunteer someone to speak on it.
Okay, so I would just, if I may just take a short stab at that. So firstly, I'm not sure what this comparison is, the purpose of the comparison. As citizens of a constitutional republic, we must be able to enjoy and exercise our rights. There have been authoritarian regimes in the past, and this regime is also using its all the power that it has. And I think it's thrown a very clear challenge to, as I mentioned before, that is electoral democracy necessarily one that promotes rights and justice? In India itself, if you were to ask the same question from perhaps somebody who resides in Kashmir or resides in the northeast of India, well, they have experienced over 70 years of authoritarianism and with militarization. And I think one thing that I think when I was hearing my co-panelists speak is that we need to pause in India and reflect that are the practices that were followed, both with the law, with incarceration, with preventive detention, which were repeatedly practiced, particularly in Kashmir. Are those now have they spilled beyond Kashmir? And are the same practices being actually used against citizens who are dissenting or organizing or opposing across the country? And I think that is something that perhaps the people of India need to reflect on.
Thank you. Are there any other comments about that? I mean, I think that's well said, personally, speaking. The other question I have actually is about what a lot of the people attending this are actually based in the US, or probably a lot actually based in other countries. And so what do you feel that Indian Americans or people, or NRIs as it were, can do here in the US or in other countries outside of India? What would you recommend that we do in order to stand in solidarity with human rights back in India?
I can kind of just jump in here, going mostly because I'm based in the US, and so I've seen Congress and how it works. Let me put it to you this way: that the people who are excusing or justifying or directly supporting this current administration are very powerful and are very loud in the United States. Not just powerful, very, very loud. So when it comes to a hearing, such as something that I wanted to do at the commission, right, when I was working there, and we want to do a hearing on India and talk about the human rights abuses and religious freedom challenges that are happening there, there's going to be calls made by individuals belonging to certain organizations to congressional offices saying this is anti-Indian, this is anti-national, this is terroristic, this is run, and look who's doing it, Vado Susan, look at his beard, he must be up to something bad, right? Which, my beard shouldn't demonstrate that, right? That should be my characters that actually demonstrate whether I'm doing something bad or not. That's not here or there, but what I'm saying is that what we don't have is people calling in from the same district saying, no, I'm very concerned about these issues. I have cousins, I have friends who are telling me in India that things are very bad. We want this kind of hearing to happen. We want to support the people who are working on the ground in India. So what I would recommend to all of us, and by the way, this isn't just because of the situation in India, this is because all of us need to be engaged with the political processes that we do have in the United States or whatever country we live in. We have to let our congressional offices know we care about these issues. We want you to look more into these issues. If there's a resolution, if there's a trade deal, if there's an arms deal, we want these issues discussed there too. And guess what? The US relationship with India has, really actually gotten more strong under this administration and previously under the Trump administration, partially because I feel that there isn't enough pressure being put on these people to say, yes, they are a security partner. We got that. That's true. Yes, they're a trade partner. We get that. That's true. Yes, they're a market for your goods. Yes, we get that. Yes, you get goods from there. But also, none of this can work unless our laws are obeyed, and our laws require that if there's human rights violations happening, our governmental actors have to speak on those, right? So if the trade deal has a provision in it that says or let's say it's a security deal, actually, because when you have a terrorism law being used to prosecute poets and law professors, you're not prosecuting terrorists then, right? And so immediately as a partner, as the US government, we have to think, okay, well, if they're misusing this law, then they can't really be a good partner for us, can they? Can they really provide security in South Asia for us? So we look at these things in different silos, as like human rights is something completely different from trade and security, but all of it goes together. And the more the community in the United States puts pressure on our government officials to know that this is important to us as constituents, that we will be voting on these issues and we want to raise them. That will give them the courage, that will give them the backing as members of Congress or as a president or as the members of the National Security Council to say, yes, we're going to go ahead and take this line, we're going to follow it down. So I would recommend be active. And then, of course, like, that's going to be a way for you to get involved in other local politics. I mean, sometimes we, as human rights people, are thinking globally, so we don't talk to our like local representative, but that's who actually can write onto a bill. That's actually who can write a resolution or give a statement on the House. That's who we've got to talk to. So we've got to educate them. And if they don't know enough about India, then we have to be amenable to saying, okay, let's help you bring you up to speed. Here's all that's happening. Here's all the disinformation that's out there. Here's what you should do, and here's what you should know. So what I would say is create those contacts with those congressional offices, speak to them. When there's issues coming up, write to them. Say about Kashmir's internet shutdown. Say about the CAA. Like, those are things that we should bring up with those offices. This is something I'm particularly passionate about, because I think like our communities in diaspora don't always think on the local level to try and get to the human rights at the global level, but that's how we can do it. In the United States, we have a federal system just like in India, so we should be able to talk to our local folks as well, our senators, our Congress people, to make action there. So that's what I would recommend for the diaspora community.
Govind, can I come in? Do we have time?
Yes, please.
Right. Varis, thank you for that. And I think everything he said is so important. But in my experience, I think there are other things as well. I think we need to educate, agitate, and organize. And I think a lot of the education has to go back to the diasporic communities. In my very limited experience, what I've really seen is many South Asians who live in the United States and Europe, who tend to be liberal politically here, could still be sympathetic to what's happening with the Modi regime. Some of them might not be members of the VHP here, might not overtly express joy, but they all do flirt with some form of Hindutva. And now increasingly you see any kind of critique of India as being immediately translated to Hinduphobia. And I think we really need to understand ways in which RSS, VHP, BJP all have over the last 35 years have built a strong cultural network, and they are not only using propaganda in India, they're using propaganda in diasporic communities as well. So we need to fight disinformation and in some ways educate, agitate, and take back our communities, and that's really important. Second, increasingly in the last few years, we saw many of them who are pro-BJP, pro-RSS, pro-BJP government, especially pro-Narendra Modi government, increasingly funnel in money in US elections against candidates who are openly speaking against Hindutva, Islamophobia. So in some ways, we also have to recognize that RSS and others actually now increasingly play a role in US elections, which goes back to RSS' point, is that we really need to educate our communities, but we also need to organize the communities. And I think a remarkable example is how various Bangladeshi communities in New York especially really came together during COVID to create mutual aid, how they have politically organized together, come together to fight against Hindutva, against Islamophobia, but more importantly, advocate for our communities locally. Sadly, while we have a handful of those happening, the predominantly wealthier Indian communities haven't done that. And I think that is where the real task is, reaching back to our communities, educating them, challenging them. But again, as I said, to be locally involved, and again, making sure that we this is a marathon. If Hindutva was a 100-year project, reclaiming our societies is also going to be a 100-year process, right? So we start today, and hopefully we do enough and for the next generation of people to take over. So the reclamation process has to also be a long-term process. And I'll kind of leave it at that.
Thank you. Very well said. I think this may be the last question, but maybe not. I was wondering, I was trying to think about how to phrase a question that came over about, I'll just put it out there and you all could take it how you want, in terms of the quality of the Indian judiciary. And I suppose it means, in terms of how, what's your perspective on whether or not the judiciary is still very independent, or what sort of expectations you have perhaps for the future. And I would say probably either our lawyers in Delhi, if they want to answer, they can do that. But I'm curious if anyone's willing to answer that.
They have to be careful of contempt of court charges too. So you got to remember, Govind, this is a loaded question for them.
That's why I was actually trying to phrase it in a way that that they can answer appropriately.
I think we need to, I'll just try and respond to that. And there is a lot of discussion around independence of judiciary in India and a debate around that. I think what we need to, the judiciary is not a monolith. We need to constantly keep that in mind. We know, of course, there is one Supreme Court in New Delhi, but there are, every state has a high court, which is a constitutional court and has actually the same powers as the Supreme Court does, give or take here and there. And then, of course, you have district courts. So there's never a one single line answer. As is famously said in India, anything that you say, the opposite is also equally true. So, and I think that that polyvocality of the judiciary is actually very, very important and is where perhaps hope lies. So yes, there are. So there is a cause for concern. And I think the cause for concern has in the last few years been primarily and much more with respect to the Supreme Court, and which is, of course, the final court. And whatever matters, whether it's a bail matter or it's a constitutional matter, the buck stops at the Supreme Court, and it does get to have the last word. And I think the reasons that have caused some amount of anxiety, for instance, we discussed today a range of issues. There have been some very significant legislations that have been passed in Parliament. So in a constitutional democracy where there will obviously have to be a check and balance system between different organs of the state, and if the executive and the government is enjoying an absolute majority in Parliament, then that no longer remains a forum where a lot of diverse opinions are going to be expressed. So when the constitutionality is challenged and there is a judicial review of, say, a law like the CAA, which for the first time, to my mind, in a completely constitutionally impermissible manner, brings in an element of faith into the understanding of citizenship and acquisition of citizenship, then that challenge has to go before the Supreme Court. Similarly, the abrogation of Article 370 in Kashmir in 2019. People are turning to constitutional courts for adjudication, even as they are taking to the streets. And I don't think the two are either or. And I don't think the court can tell people not to exercise other rights, because in a democracy, we will organize, we will, it's a way of forming public opinion, which eventually should also impact electoral politics. All those matters which are not only because they are extremely significant in constitutional terms, but clearly are of huge public concern if people are out on the streets. Yet we see that the court did not take them as matters which needed urgent attention. Whatever the court may decide, but the court has not even actually found time to engage with those issues, to listen to what are the concerns that citizens are voicing, that people are raising. And that has caused a lot of anxiety, because that then further strengthens the position that the government, with a majority and a lot of force on the streets which it can summon, is able to then project that, whatever we say, our writ will run. And that balance that is important in a democracy where each institution is responding to serious concerns, that then gets jeopardized. And as I said, I cannot speculate what the court will do. But if, for instance, in an Article 370 matter, which an abrogation that takes place in 2019. We are now in 2021. 2 years are over. There are certain shifts that the government is making, which may become irreversible. How will the court then deal with those situations? So that causes a fair amount of anxiety. The whole process of the NRC has again been a cause for concern, or awarding a Chief Justice of India a position within a few months in the Rajya Sabha, particularly a Chief Justice of India who did not cover himself in glory, in fact, had very serious sexual harassment allegations. And I say that with responsibility, having represented the woman. So these are, would this cause some amount of anxiety in the mind of a common person and a citizen for whom this particular forum becomes more critical when the configuration in the parliament has changed, when this particular political party has monetary and other resources at its command, which has not been there before. I think some of the concern
You may have lost Brenda Grover there, but it actually is 10 o'clock. I hate to cut off her quite eloquent and excellent answer, but that's the world we live in, where we may have our Zooms cut off. So, but I do want to thank everyone for attending, and I especially want to thank our panelists who were incredibly informative. I actually learned quite a bit about the state of human rights in India from this, and I hope that you stay tuned to the attendees. I hope that you continue to join these webinars. They come about every 2 weeks, and and it will also be presented on YouTube and Facebook, and you can share it out on there. So with that, I'd like to end this particular panel. So thank you very much. Take care.